Imagine John enters into a debt without telling his wife, Jane. Is Jane liable for the debt? In Sunkidd Venture Incorporated versus Snyder-Entel, we explore what constitutes a community debt and each spouse's liability for such an obligation. In March of 1988, William Entel entered a 6-month apartment lease. Shortly thereafter, he married Shannon Snyder-Entel. She moved into the apartment without being added to the lease. When the lease's expiration drew near, the property management company sent William a form, allowing him to extend the lease for 1 year on the same terms. William signed the form, returned it, and then informed Shannon of his actions. A few months into the extended lease, the couple decided to move, and Shannon sent the management company notice. In response, the company sent William, the recorded tenant, a bill for over $3,500 covering rent for the remaining lease term and various fees. Shannon responded, denying liability for the charges. Eventually, the management company assigned the debt to Sunkidd Venture Incorporated for collection. In May of 1991, Sunkidd sued Shannon for the balance owed on the abandoned lease. The Entels divorced in 1993, and Shannon responded to Sunkidd's complaint in 1994. She argued that she wasn't separately liable for the debt because she never signed the lease. Sunkidd countered that the debt was a community debt for a family necessary, and it was therefore enforceable against Shannon's separate property. The district court held in Shannon's favor, finding her not liable because she didn't sign the lease and had no notice before William executed the extension. The Superior Court affirmed, and the Washington Court of Appeals granted review.